going to be a very quick sort of trawl through some of the highlights that, as Sam said, have taken place over the last 18 months or so. They're not all computer-related cases, but they are ones that I think are clearly relevant to contracting in relation to IT and computer topics generally. The first case I just wanted to mention quickly was the Smith Salvage case, which related to the grounding of the large container ship, the Ever Given, in the Suez Canal a few years ago, that hit the headlines in the news. And this was a dispute between a salvage company and the ship owners. And the question was whether a binding contract had been agreed between the ship owners and the salvage company. Now, it was alleged that a contract had been formed through an exchange of emails following a written proposal by the salvage company. And interestingly, the emails had actually agreed the basis upon which the salvage company would be remunerated. Now, the fact that they actually had done the work and the price that had been agreed, you might have thought that the court would find that there was a binding contract in place. However, in this particular instance, the parties had continued to negotiate some detailed terms and conditions, and they'd been exchanging draft documents with substantial amendments on both sides. Agreement was never reached on the final details of the contract, and indeed the contract was never signed. Now, given that the parties had not expressly stated what point a contract was due to come into existence, the court said that the intention regarding contract formation had to be determined by considering what the words and conduct of each party had reasonably conveyed to the other. In other words, what objective appearance had they given? And the court said that there were no hard and fast rules for determining when a contract came into existence, and that each case was dependent upon its own facts. Here, the court held that there was no contract that had been concluded, despite the salvage company actively helping out with the salvage operation. Now, that's relatively unusual. A couple of points coming out of the judgment. First of all, the court said that just because the parties were contemplating a fuller set of contract terms doesn't mean that there couldn't be an intention to be bound prior to that. In other words, if all the fundamental terms had been agreed, then potentially a contract could come into existence at an earlier stage. And also, just because you haven't used subject to contract doesn't mean that there was an intention to be bound. So although using subject to contract label, if you like, is obviously a good indication that you don't intend to be bound by an exchange of emails. What the court said was a substantial performance of a contract may be a powerful indication of an intention to be bound, but ultimately each case will depend on its own circumstances. In this particular case, the court said that the parties had made it clear to each other that they only intended to be bound once the detailed set of contract terms had been agreed. And the key lesson from this case is make clear your intent right at the outset. So if you don't intend a contract to come into existence until all the terms have been agreed, then make that clear. Otherwise, you might find yourself being subject to a contract when you don't really intend to be. The microlise case is another one on contract formation, which I mention here because it contains so many lessons of what not to do when you're trying to form a contract. Now, here there were really three issues. When had a contract been formed and which terms applied? Who were the contracting parties? And then I'll just move on to mention the question of reasonableness under the Unfair Contract Terms Act. Now, here the supplier, Microlise, issued a number of different quotations. The first quotation contained a full copy of their general terms. Now, this was 2 pages of detailed legal terms, which by common consent, they appear to Sorry, let me just start that again. So the supplier issued a number of different quotations. The first quotation contained a full copy of their general terms, but there was a rider to the quotation which said, you agree to Microlize's standard terms and that these standard terms were available on request. After issuing the first quotation, Microlize subsequently issued quotations 2 and 3. Now, these were accompanied by a different set of terms and conditions, in fact, a detailed framework agreement, which was never actually signed. Now, what happened was the customer in this case returned an email with the first copy, the first page of quote 2 duly signed. And the question was, which set of terms and conditions applied to this contract? Now, this was a form of the battle of the forms, if you like, but it was actually a battle between two sets of terms, both belonging to the supplier. What the court said was that when quote 2 was returned, signed by the buyer, that was effectively an offer to buy. And that offer to buy was accepted when the supplier actually began performance. Now, interestingly here, the detailed framework agreement was held to be the terms governing the contract. Despite the fact that that agreement wasn't signed, that was held not to be fatal. Again, what the court said was that in determining which set of terms and conditions governed the contract, he said an objective assessment of the parties' intentions depend not upon what the subjective state of mind of the representatives, but a consideration of what was communicated between them by words or conduct. Now here, obviously, Microlize had made a number of mistakes. First of all, issuing what was effectively two sets of terms and conditions and not making clear which one was intended to apply. They also made another really quite significant error in that during the course of the negotiations, they issued 3 different sets of the framework terms. So there was clearly a moving feast, if you like, as to what terms and conditions should have applied. Then in terms of the contracting parties, now the quote that was issued by Microlize were all issued to something called the Uniserve Group. But actually, that wasn't a legal entity. It's not an entity that you can contract with. And the framework agreement, when that was issued, also referred to the Uniserve Group as the customer. Now, when the quote was returned, Uniserve signed that as Uniserve UK Limited. And that same company was listed on the supplier's new customer form. At some later point, a company called UHL, which was the parent company of Uniserve UK, was listed on the supplier's new customer form. But actually what happened in practice was that individual orders placed under the framework were issued by various individual companies as part of the Uniserve Group. And what the court found was that actually a contract was formed between each of those ordering customers and Microlize, incorporating the terms of the framework contract. So what I would say here is that Microlize were really quite lucky. First of all, they were very unclear as to what contract terms they wanted to apply. And then secondly, they made a real hash of determining who exactly they were contracting with, who was their customer. You need to have absolute certainty as to who you're contracting with. Otherwise, you could find yourself exposed to claims from people that you've not had contact with, or indeed you have a binding contract with an entity which doesn't exist. The final topic in this particular case featured the limitations and exclusions that were present within the framework agreement. Now, first of all, the exclusion clause. In the framework agreement, it was stated that the supplier should not be liable for any indirect or consequential loss the customer may suffer even if such loss is reasonably foreseeable or if the supplier had been advised of the possibility of the customer incurring it. Now, there was an argument about whether this exclusion was fair and reasonable under the Unfair Contract Terms Act. And what the court said was that essentially in this particular case, the parties were regarded as being of equal bargaining strength. And also, interestingly, they referred to the clause being commonly used within the sector. And what they did was there was actually an analysis of a number of typical contracts that were used by Microlyzer's competitors. And that significantly helped the supplier in their argument that the contract, that the particular clause in question was perfectly reasonable. A few other comments by the court. The court said that indirect and consequential losses are widely accepted as the same thing, and I would agree with that. They then went on to say that such a phrase excludes losses which do not result directly and naturally from the breach, but which nevertheless were or must be reasonably be supposed to have been in the contemplation of the parties. Now, the key thing here is that an exclusion of indirect and consequential losses does not exclude losses which arise directly and naturally from the breach. In other words, they exclude relatively little. And that's been a message, that's not new law, that's been a message which has been around in cases for many years, but it's always worthwhile revisiting this just to remind yourself that that type of exclusion is of limited value if you're a supplier, or excludes relatively little if you are a customer. What the court said was that in assessing reasonableness, you have to assess it at the time at which the contract is made. And therefore, the court was not supposed to be taking into account the nature or seriousness of the loss which was actually caused. One of the other points that the judge made was he said that as a matter of construction, this exclusion of indirect and consequential loss did not seek to exclude loss resulting from pre-contractual statements. Now, that's obviously a fairly significant area of exposure, particularly in an IT context, or can be. There was then a separate limitation of liability as shown on the slide. So it said the supplier's entire liability to the customer in respect of any breach of its contractual obligations, any breach of warranty, any representation, statement or tortious act or omission, including negligence, arising under or in connection with this agreement, shall be limited to £1 million. Again, the court considered this limitation and upheld it as being fair and reasonable under the Unfair Contract Terms Act for exactly the same reasons as before. They said the parties were of equal bargaining strength and the clause was something that was commonly used in the sector. Now, interestingly, the judge did make a comment, which I have to say I found surprising given the drafting that I've just shown you, in that the court did say that there was some question mark as to whether that limitation clause would catch any liability for misrepresentation. I would have thought it should, given that it did expressly refer to any breach of representation. But nevertheless, that was a comment that the judge made. I have to say I'm not surprised that the judge upheld this limitation of liability clause. I don't actually off the top of my head remember how that bore in relation to the actual value of the contract, but £1 million is a fairly sizable cap on liability. But one point for the suppliers amongst you to note was that the liability was capped under the agreement. And although it wasn't part of the judgment, that does at least draw into question, did they mean an aggregate cap under the framework, or was that a cap per call-off contract? Because obviously if it's £1 million in aggregate, as opposed to £1 million per call-off, that's quite significantly different. Next, a case which received a great deal of publicity at the front end of last year. That's the Soteria case. And it was quite controversial because the High Court judgment concluded that a loss of profit exclusion excluded a claim for wasted expenditure, including sums paid to the supplier, IBM. And when the case went before the Court of Appeal, the case was roundly overturned by the judges in the Court of Appeal, who made it very clear that the natural and ordinary meaning of the words used, i.e. the loss of profit exclusion, was not apt to cover or include wasted expenditure. And the court said that the more valuable the right, the clearer the language of any exclusion clause will need to be. Now, I have to say, I think the Court of Appeal judgment here has to be right on its drafting and on the facts. The court said claims for loss of profit, revenue and savings are types of potential loss, which because of problems of speculation and ascertainment are routinely excluded. However, claims for wasted expenditure are an entirely different animal. If the victim of a breach of contract has spent money in anticipation that the contract will be performed, then that loss is easy to ascertain. There will be invoices, contracts and receipts. This type of loss is the exact opposite of a speculative claim. It is precisely ascertainable. It is a pure accounting exercise. The claims that would have compensated Soteria for being better off as a result of the new IT system were therefore excluded. But claims to compensate them for being worse off as a result of the non-provision of the IT system were not. And the court felt that struck a fair commercial balance as between the parties. The court went on to say that characterization of wasted expenditure as a method of calculating lost profits, revenue or savings involved an unjustified leap of reasoning. Whilst lost profits is one method of calculating damage for the loss of a bargain, a claim for wasted expenditure is a different method of calculating such damages. This does not mean that wasted expenditure is a method of assessing or claiming lost profits. The next case I just want to mention to you is the case of Evans v. Joseph. Now again, this has a number of interesting aspects to it. This was an IP license in respect of design rights for various kitchenware items. Now there was, as part of the contract, an obligation in relation to a particular thing where the parties had to reach mutual agreement. And there was a dispute about what that actually meant, although I have to say I'm quite surprised that the parties would try and litigate on something like this. But in particular, what one of the parties argued was that there was an implied duty of good faith, and that in reaching agreement, the parties had to act in good faith. What the court said was, in dismissing that argument, it said it cannot be said that a reasonable reader with the relevant background knowledge would read that phrase as importing an obligation to discuss in good faith the basis of the decision, or otherwise to require a party to consider the basis of the counterparty's position in good faith. In other words, basically, parties mutually agreeing meant exactly what it said. Both parties needed to agree, and there wasn't an implied duty of good faith obliging them to act reasonably or honestly or otherwise in good faith. Now, that's not a surprise, and it does reflect the sort of traditional view of good faith under English law. There was then a separate phrase whereby one of the parties was obliged to use best efforts, and it was accepted by the court that best efforts has no difference in meaning to best endeavours, so those two phrases can be used interchangeably. What the court said was that whether an obligation to use best efforts has been satisfied is necessarily a fact-sensitive inquiry. The best efforts obligation in this case extends in principle to taking all reasonable steps. Now, I have to say, again, this is not creating new law. It's simply repeating some judgments from several years ago. But it does no harm to remind ourselves what a best endeavours or best efforts clause means. And it is quite confusing because one would have thought that best endeavours did not, you're confusing their best endeavours and reasonable steps. So it's very easy to see how things can get confused. Best efforts is not an absolute obligation, and there are limits according to the specific facts. Now, the judge quoted an old case from 1980, an IBM case, where they said a best endeavours commitment is to take all those steps in their power which are capable of producing the desired results, being steps which a prudent, determined and reasonable owner acting in his own interests and desiring to achieve that result would take. Now, again, I highlight this statement because, again, it's defining best endeavours with regards to reasonableness, the acts of a reasonable owner. But also there is a balancing act to be had here. So as the bits that I've highlighted, so the person who is subject to the obligation to use best endeavours is being judged when acting in his own interests, but also desiring to achieve the particular result in question of the endeavours. Now I have to say, I've always thought this is a bit misleading, because to define best endeavours in this way, I think means that it's a relatively low threshold. If you, after all, if you're acting in your own interests, then if something is going to be more costly for you to perform than it's going to be worth to actually perform it, then actually, according to this formulation, it would seem that the steps that you have to take might be quite limited. So just bear that in mind if you're either giving or receiving a best endeavours commitment. The Faulkner case that I want to mention concerns an express obligation in good faith. Now, it is becoming increasingly common, one sees in contracts these days, that contract drafters are including express obligations of good faith. And the question is, well, what does that actually mean? What obligation does that import into the contract? Now, in this particular case, the judgment said that the meaning of the phrase good faith is highly context specific. And in particular, they said that cases from different subject areas can be of limited value. It's not always easy to draw a conclusion from a case in one area and apply it in a completely different area. However, what the court did say was that a duty of good faith is not overly demanding. And equally, the court said a duty of good faith is not necessarily the same as a requirement of honesty. Some cases had said that a requirement of good faith was effectively just requiring a party to act honestly. In coming to this judgment, the court specifically overruled an earlier case of Unwin and Bond from 2020, which suggested that a duty of good faith imposed a number of minimum standards, including to be faithful to the agreed common purpose of the contract, to deal fairly and openly with your other contracting party, and in particular to have regard to the interests of that other party, which is obviously quite significant. The Court of Appeal said they didn't like this formulation and it was completely inappropriate to mechanically apply such minimum standards. The court highlighted that a duty of good faith involves really a core duty of honesty, but they then went on to say that depending upon the contractual context, a duty of good faith may be breached by conduct which would be regarded as commercially unacceptable to reasonable and honest people, albeit that they would not necessarily regard it as being dishonest. But I think the general takeaway here is that an express duty of good faith is not terribly onerous. And a core duty of honesty, and as I say, conduct which would generally be regarded as commercially unacceptable. Providing you can pass those tests, then you ought to be abiding by a good faith obligation. The next topic I just want to cover briefly concerns limitation of liability clauses again. They're obviously a very pertinent question for computer-related contracts. And this is a good example of where the courts have got to very recently. So in Benkert against paint dispensing in the Scottish Court of Sessions, there was a limitation of liability clause to the annual value of a maintenance contract. This was a maintenance contract for printing equipment. and the annual value of the contract was just £3,225. However, there was evidence that the claimant had suffered a fire because of the way that the maintenance contract had been carried out. The damages claimed was something in the region of £29 million. The service provider had relevance insurance of £5 million. What the court said was that it was unrealistic for the court to ignore the size, scale, and resources of the respective contracting parties, and that this was a factor likely to have a bearing on the relative bargaining power. Commercial parties are generally the best judges of what is fair and reasonable for them. Looking at the particular clause, it was clear that the supplier had gone to some lengths, including by titling the introduction to the particular limitation of liability clause by putting it in capitals, as I've shown on the slide. They said that was designed to catch the eye of anybody flicking through the contract. The court then went on to say that to expect the service provider to obtain insurance sufficient to cover very substantial losses sustained by each of the customers, the nature and extent of which they were in no position to estimate, would be entirely unrealistic. The fact that the service provider held public liability insurance and disclosed this fact when asked as part of the contract negotiations was irrelevant in the context of considering whether the contractual limitation clause was fair and reasonable. The court said that it was not solely concerned with whether insurance was available to the service provider, but with a broader question that takes into account the commercial realities associated with obtaining insurance, including the cost. The court therefore upheld the limitation as being fair and reasonable. Now, I have to say that that is a fairly extreme example, but it is nevertheless an example that is entirely consistent with the latest trend in court decisions that we've had over the last few years with limitation of liability clauses. But don't assume that just because you are following standard or industry standard practice that your limitation clause will necessarily be upheld. You do get examples of cases which come out of the blue, which can mean that limitation clauses are struck down as being unreasonable. And the kitchen components case is one example of these. Now, again, this is not an example from a computer-related context, but I highlight it just to show how different courts can take different positions. So here, the seller had limited their liability by saying they were entitled to replace the goods supplied free of charge, or at their sole discretion refund the price of the goods or a proportionate part, but the seller shall have no further liability to the buyer. In other words, the limitation of liability was effectively the contract price paid. In this particular case, the supplier was able to and did obtain insurance against the risks that materialized. And the court said that it was more appropriate that the risk of loss from such a defect should fall on the supplier. The court found that the limitation clause did not therefore meet the requirement of reasonableness. Now, as I say, I have to say this is quite an exceptional case, and it remains to be seen whether it is followed in other cases or not. I have to say it's unlikely, but you do bear that risk whenever you're limiting or excluding liability. The next topic I just want to look at concerns data protection liabilities. And in particular, I'm going to refer to a Procurement Policy Note issued in December 2022 by the Cabinet Office, which was a guidance note, if you like, for public sector bodies in relation to personal data related liabilities. Now, the policy note included an Annex A, which was effectively a template set of GDPR clauses. And I have to say, in the main, they are relatively uncontentious. They do follow the statute by and large. But just a few points to note. First of all, the clauses require the data processor to provide all reasonable assistance with the preparation of any data protection impact assessment. Now, of course, depending upon what's involved with preparing the data protection impact assessment, that could be quite costly in terms of the time that would be required, time and effort that would be required to produce such an impact assessment. So just bear that in mind. Also, the standard clauses oblige the data processor to notify the controller immediately upon becoming aware of a data loss event. And a data loss event is defined quite widely as any event that may result in unauthorized access or potential loss or destruction of personal data. So here there is an obligation to notify even when you think something might lead to unauthorized access, and not that it's simply been established that it has led to unauthorized access. That's quite a low threshold, which could mean that you're notifying quite regularly, depending upon events which you've managed to see off. Also, there is an obligation on the data processor to provide full assistance in relation to the data controller's obligations under data protection legislation, including providing assistance as requested by the controller following any data loss event. Now, I've put there, is that chargeable? And the reason I mention that is a data loss event is simply an event which may result in unauthorized access to or potential loss or destruction of personal data. It doesn't necessarily mean that you were responsible for that data loss event. So you could be requested to take some action in circumstances where you were not in breach. And arguably, you might want to consider whether you would be able to charge for the time spent in providing that assistance. Another point to note in the policy note is it says that the controller may, upon 30 working days notice, amend the agreement to ensure it complies with any guidance issued by the Information Commissioner's Office. Now, I just make the point here that this places the risk of a change in the guidance with the data processor, which could, of course, be expensive. And of course, 30 days notice may not be sufficient in all cases to enable you to comply with any change in the guidance. But the real point that I wanted to highlight from the policy note was a section 23 dealing with contractual liabilities for data protection, which are a highly contested area of computer contracting these days. What the policy note says is there are a range of options to be considered to ensure that the controller is able to recover full costs of civil data protection, related claims or regulatory fines issued by the Information Commissioner's Office where the processor is at fault. I highlighted the word full costs, recovery of full costs. In other words, they appear to be envisaging an indemnity. And what the policy note says is that you should potentially consider excluding data protection breaches from the general cap on liability, increase the general cap on liability to ensure that it covers higher regulatory fines, have a separate cap on liability for all data protection breaches, and indeed introduce a separate £17.5 million cap on liability for regulatory fines arising out of data protection breaches. So here, the policy note is clearly envisaging either unlimited liability or extremely high caps on liability, a £17.5 million cap for a contract which might only be worth 10,000 or 100,000 or even £1 million. That's still a huge potential liability. Section 24 of the policy note then goes on to include a very strange, in my view, comment. It says in-scope organisations should apply commercial judgment when considering whether substantial changes to or additions to liability and indemnity clauses should be made in accordance with the change in law provisions in contracts. Now, I have to query this and say, is it really the case that a change in law provision has any application to entitle a public sector body to unilaterally change a limitation of liability clause in a contract? I really don't think so, but nevertheless, that's what Section 24 is inviting organisations to do. On the plus side, it has to be said in recent times, the Information Commissioner's Office has begun to prefer making published reprimands to data controllers rather than issuing large fines. Decisions on damages and costs awards have themselves limited exposure. I mentioned too the Lloyd against Google case and the Warren against DSG retail case, which have really highlighted the fact that what people thought might be very big class actions for data protection breaches have, at least for the time being, turned out not to be quite as worrisome as might have been thought. A couple of clauses that I've come across recently that I just wanted to highlight to you because they seem to me to have some quite interesting features to them. The first was an arbitration clause expressed in these terms. It said the arbitrator is not authorised to award damages in excess of the limits provided in this agreement, nor to award damages expressly excluded in this agreement, and the parties waive any award to the extent that such damages are not authorised. Now, this was clearly an attempt to limit liability in a different way, if you like, by expressly saying that the arbitrator doesn't have the power, is not given the jurisdiction to award damages in excess of those expressly agreed in the contract. That's another way of sort of underwriting the limitation of liability clause that you include within your agreement. I have to say I've only ever seen this in one contract. How it would be regarded by the courts, I don't know, but it is an interesting exercise, I think. The second thing I just wanted to point you to was this particular clause, which was one which said the total liability of the supplier, including attorney's fees awarded under the agreement to the client for any claim by the client, will be limited to whatever it was, £1 million or whatever it might be. Now, this is quite interesting because here the limitation of liability clause is expressly including within the cap on liability for legal fees. Now, that's relatively unusual, but given that legal fees can often be a very substantial part of any claim, that could significantly impact on the value of a limitation of liability clause. And finally, by way of an example, here was some drafting which says the aggregate liability of the supplier should be limited to the total amount of charges, excluding VAT paid by the customer to the supplier. Now, it's the words in brackets which are quite interesting here. Very often VAT isn't referred to in limitation of liability clauses, but it may impact your liability clause by as much as the rate of VAT. So something worth bearing in mind. On the subject of legal fees and liability caps, I mentioned the Equitex biomass case from 2021. Here, there was a contractual cap which is expressed as applying to liability in respect of any claim under the sale and purchase agreement for breach of warranty. Now, the dispute which came before the court was whether this included or covered liability for legal fees. And the court said that the limitation did not extend to claims for interest or costs, the award of which would be made pursuant to the court's jurisdiction to make ancillary orders rather than being made under the agreement itself. The court considered that in respect of was wide, but not as broad as arising out of or in connection with, and said that that would have been broader. It would have expected interest and costs to be mentioned expressly in the liability cap if the parties intended that important litigation rights were being foregone. That caused me to look at some well-known public sector IT contracts. Now, the first example here is from the DOS5 framework, which caps liability in each contract year under this contract, whether in tort contract or otherwise. It's probably the narrowest limitation in the sense of being very unlikely to include any award of legal fees because of the under this contract language, as in the case that I've just mentioned. So I think there, if you were looking to argue that that liability included liability for legal fees, I don't think that would be the case. Similarly, here under the G-Cloud framework contract, this limits liability to each party's total liability for defaults under or in connection with this call-off contract. Now that follows quite closely the wording which was commented on by the judge as being a much broader formulation. But I have to say my suspicion is that the court would still be more likely to say that any recovery of legal costs was additional to the cap. However, the final example that I want to give you is from the CCS Model Services contract. Now, this defines the supplier's aggregate liability in respect of all other losses incurred by the authority under or in connection with this agreement as a result of defaults by the supplier shall in no event exceed. So that caps liability. However, losses is a defined term. And here, the model contract explicitly defines losses as losses, liabilities, damages, costs, and expenses, including legal fees on a solicitor-client basis, judgment, interest, and penalties, whether arising in contract, tort, including negligence, breach of contract, breach of statutory duty, or otherwise. So here, arguably, by trying to include within the definition a sort of kitchen sink, and by including legal fees within the definition of losses, arguably, whatever cap is stated within the CCS Model Services contract is inclusive of legal fees, and legal fees would not be claimable in addition. I think that's an interesting drafting. I don't know whether that's been done deliberately or by accident, but it's certainly something worth bearing in mind, because that may make a very significant difference to the actual value of a limitation of liability clause. And just finally, I just wanted to touch on force majeure, which has been in the news over the last 2 or 3 years, particularly as a result of the pandemic. Now, as most of you will know, force majeure does not apply automatically under English law. It only applies if you have expressly incorporated a force majeure clause into your contract. And the scope of the force majeure clause is entirely a creature of drafting. Now, I have to say what we saw 2 and 3 years ago was that people suddenly started scrabbling to start drafting their force majeure provisions. If you were a supplier, you wanted to expressly include coronavirus and other pandemics and so forth within your force majeure clause to make sure that you weren't liable if you were unable to perform because of problems with your workforce, etc., or because of a lockdown. But I just give these 2 examples here, which just show the way in which you have to pay particular attention to force majeure clauses, particularly in the current climate. A couple of interesting examples here. So the first example, force majeure being any event or occurrence that is outside the reasonable control of the party concerned and which is not attributable to any act or failure to take preventative action by that party, including acts of terrorism, epidemic or pandemic, but always excluding coronavirus. So here, basically, what the party drafting this clause is saying is that you can't rely upon coronavirus as being an instance of force majeure. Likewise, a second clause saying any reasonable delay or failure arising directly or indirectly from coronavirus shall not be regarded as an event of force majeure. Now, I can see that we could have arguments about that, but it does mean you do have to pay close attention to the detailed drafting of your force majeure clause. So that's a very quick whiz through the contract topics that I wanted to cover tonight. I hope you found that interesting, and I'm now happy to take questions.
Thanks, Paul. I think we've got one question from Stephen Castell. Stephen, I can read your question, or I'm very happy for you to summarize your question, ask Paul directly, if you want to unmute yourself. Perhaps I need to unmute Stephen. Let me.
Why don't you read it out, Sam?
Yeah, okay, fine.
Oh, yeah, sorry, can you hear me now?
Yeah, I can, yeah.
Yeah, I was just going to say the same thing. I think I would only say what is written, so Sam, by all means, press on.
Okay, fine. So Stephen has asked, would ICT expert witness opinion not be sought relevant and vital to assist the court as to understanding what is best when the endeavours are those specifically relating to established software and systems and network professional standards and practices and project management principles?
Well, almost certainly expert evidence would be admissible and would be required in order to determine what was thought to be compliance with a contractual obligation. All I'm really highlighting is that you do need to be aware of what particular wording, what the latest interpretation of particular wording means. I've always said that a best endeavours obligation or a reasonable endeavours obligation, they do have particular legal meanings and they're not terribly onerous very often. I think a lot of people think that a best endeavours commitment means you've got to bankrupt the company. And according to the drafting that I've highlighted, very often that's not the case.
Stephen, does that answer your question? Take silence as yes, unless Stephen can't unmute. Any other questions? If you can't unmute yourself, I have unmuted everybody, so there's a couple more messages. Can't unmute, but all okay. Thanks, Paul. That's from Stephen. I got another question from Fran saying, we use the term commercially reasonable endeavours. Is that better?
Commercially reasonable effort or endeavours clearly does introduce the concept of commerciality. But as I highlighted in the judgment, a best endeavours commitment does enable you to take account of your own commercial interests. So commercial endeavours is perfectly acceptable. To be honest, what I always try and do is try and define more clearly what you mean by a best endeavours commitment or a reasonable endeavours commitment in the contract, so that the parties are not reliant upon the vagaries of legal judgments, but they have agreed between themselves what action is required in particular circumstances and what can and cannot be taken into account in determining whether a party has abided by their obligation or not.
Thank you, that was helpful. Thank you very much.
Thanks, Fran. Thanks, Paul. Any other questions? I think there is the potential to unmute. So obviously, Fran found the way. I think. Any other questions for Paul?
Stunned silence.
Free legal advice. That always gets questions, Paul.
Can I ask another question if nobody else is shouting up? And I did get something pop up on my screen which said that I've been given permission to unmute, so I don't know if you need to do that for everybody.
Okay.
Oh, I forgot my question now, sorry. It sounded like, Paul, that what you were saying on, so from a supplier's perspective, which is what I would be, that it would be helpful to, on the limitation caps, it would be helpful to add in some of the extra things around legal fees and potentially VAT, which I've never seen before either, but particularly on the legal fees, but actually including them is, from a supplier's perspective, is a good thing. Did I understand that correctly?
Yes, so all I'm really saying, it's always amazed me, to be honest, how we've over, as long as I've been practicing law, which goes back very many years these days, we all draft and have big arguments about limitation of liability clauses, but historically nobody has addressed the sort of elephant in the room, which are legal fees. Because once you get into a dispute, the question as to whether or not you can recover your legal fees or whether they're included in the cap on liability is, can be absolutely massive. And therefore, I'm surprised that it hasn't been more common to expressly state whether legal fees or not are included within the cap. Obviously, from a supplier's perspective, yes, if you can get away with including legal fees within a cap, any liability for legal fees within a cap, then that has to be to your advantage. Of course, what might happen is that your customer may say, well, if you want to include legal fees within a cap, we're going to want a bigger cap. And so agreeing a limitation of liability clause is always going to be a matter for commercial negotiation and agreement. But certainly, and whether you will get away with that or not is, again, must be open to question. But you should at least think about the topic and say, if I'm going to agree to a limitation of liability, should that include my liability for legal fees as well? Or should that, am I expecting that to be on top of that? Because you could find that you have, say, £100,000 claim, but you're faced with a legal bill of, say, £1 million from the customer that was bringing the claim in the first place. And that could be very significant if that's outside the cap.
Thank you.
Sam, I think I can now unmute my microphone. May I come in with another question to Stephen?
Sure, Stephen. Yeah.
Just right off the wall, nothing to do with what you talked about. Let's talk about AI. Let's talk about Kevin. Have you seen any evidence yet of contracts taking account of AI in any way? I'm thinking in particular, maybe on referring to some AI tool to assist in determining compliance as a provision, because there are some tools being developed, may even be available, not necessarily just in software cases, I'm just thinking more generally. But secondly, kind of coming out from that, whether there's any discussion amongst lawyers about whether often it gets exercised in court, how exactly the contract came into being. The actual historical paths can sometimes be an issue as to who did the first draft, who did the second, who added what, who deleted what. The actual arriving at the contract process can often become a litigious issue. Not very often, but it can. And given that a lot of lawyers are now starting to use ChatGPT-4 or even other special tools for lawyers, I wonder if you've come across any of that issue yet.
Short answer is no. I think it will take a while before cases like that or involving AI come before the courts. But undoubtedly there will be legal developments, there'll be contractual developments as a result of AI. It will affect drafting practice, it will affect the way in which dispute resolution takes place and so forth, but it's very difficult to estimate what those impacts are likely to be at the moment. I think everybody is looking into the crystal ball to try and work out what's going to happen. So sorry, I can't offer any greater insight than that, I'm afraid.
That's kind of what I thought you'd probably say, because it is early days. I would just add, as many people know, I have already done a case. I can't say anything about it. It was a Finra arbitration, so it was all private and confidential, but it was specifically about an investor with a managed fund by probably the world's largest funds management company, having had a position closed out by an algo trading algorithm which the fund was using, and it was alleged done so negligently and allowing him to lose quite a lot of money on the trade. So he brought an action under a Finra arbitration, and I was asked to put forward some proposals for getting disclosure of their software. the Finra arbitrator didn't seem to know what was going on, frankly, and it was one individual against a mighty corporation. So we were, and because it's arbitration, they weren't obliged to do disclosure and discovery as they might have been in a federal or state court. It's a USA case. So we never did get to look at the actual software, but it was going to be quite interesting as to what software you look at and what you could actually deduce from it, because one got the impression they themselves did not know what their own software did, or who was responsible for actually, who could be traced through as a human to be responsible for the actual trade that was taken. And that was going to be quite an interesting issue, but unfortunately we never got the disclosure order from the arbitrator. But it's interesting. I can imagine that's going to happen quite a lot in future.
I'm sure it will.
Thanks, Stephen. Any other questions? No? Okay. Well, thanks for your attention and for dialing in. Paul, thanks again for supporting the BCS Law SG. Really appreciate it. And I'm sure the audience have taken a lot from it. So no, thank you for your time. And yeah, I hope you have a good evening. This group is for all of you. So if you've got any ideas or if you want any presenters to speak on a particular topic, feel free to email any members of the committee or myself in terms of presentations, and we will try to secure an appropriate speaker. So yeah, I will leave it with that. And yeah, have a great evening, everybody. And thank you. Bye.
Thanks, Sam.
Thanks, Paul. Bye.
Take care.
Bye.
Bye-bye.